Hello friends, today I am talking about the important provisions of the Environment Protection Act of 1986. So this act was created to provide for the protection and overall improvement of environment in our country and for the matters related with environment. So India is signatory of United Nations Conference of Human Environment, which was held at that time in 1972, June 1972, and that was the first step at international platform to protect and improve the human environment. A number of countries participated in it and they agreed to do it. And nowadays the protection and improvement of the environment and prevention of the hazardous substances, protection of human health, other creatures, plants and the property is very important. So it is enacted by the Parliament in 37th year of Republic of India. So chapter 1 is a preliminary chapter as usual in number of acts, number of laws, which contains the short title, extent and commencement in general. So this act may be called as Environment Protection is in bracket, Act of 1986. So in short, even it is also referred as EPA, Umbrella Act. It extends to the whole of India. The original act I am talking here, it came into force after publication, its notification in Gazette of India. So there are some important definitions defined under this law. Environment includes the water, air and land and its interrelationship which exists among and between water, air, land and human beings and other living creatures, plants, even microorganisms and even with the property. Environmental pollutant is also defined under this law, means any solid, liquid or gaseous substance present in such a concentration as may be or tend to be injurious to the environment and its components. Environmental pollution means the presence in the environment of any environmental pollutant. So what is meant by handling? It was defined under this act. It means any substance, the manufacture, processing, treatment, package, storage, transportation, so use, collection, even destruction, conversion, offering for sale, transfer or the like of such substances. It means handling. So hazardous substance is also defined under this law, means an substance or preparation which by reason of its physico-chemical properties or handling is liable to cause harm to the human beings and also to other living creatures, plants, organisms, microbes, I am talking, property or the environment in general, overall environment. So who is occupier? So in relation to factory, premises, industry means the person who has control, employer over the affairs of the factory or the premises, and includes in relation with any substance the person in possession of the substance is an occupier. Prescribed means prescribed by the rules made under this act. So this is legal word. So under chapter 2 there are general powers of the central government. So try to understand the importance and role of central government as per these provisions of this act. So power of central government to take measures to protect and improve the environment. So necessary for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating. See, prevention, control and abatement of the environmental pollution. So what central government can do? Coordination of the actions by the state governments, officers and other authorities. So under this act are the rules which are made there under. So are under any other law for the time being in force which is relatable to the objects of this act. What they do? Planning and execution of nationwide programs for the prevention and control of the abatement of environmental pollution. So no further pollution, environmental pollution in our society. Laying down the standards for the quality of environment and its various aspects. So development of standards. Laying down standards for emission or discharge of environmental pollutants from various sources. So this is as part of air pollution and industrial wastewater, effluents. Again, what they can do? Restriction of areas in which any industries, operations or processes or certain industries or operations or processes shall not be carried out or shall be carried out with certain or to certain safeguards. So its decision is with central government, its power. Laying down the procedures and safeguards for the prevention of accidents which may cause environmental pollution and to take the remedial measures for such accidents. Again, central government lay down the procedures as well as safeguards, guidelines for handling of hazardous wastes. So that was very important at that time when first time this act was developed. Again, examination of such manufacturing processes, materials and substances which may likely to cause environmental pollution, carrying out and sponsor the investigations and research relating to problem of environmental pollution in our country. Again, they have power to inspect any premises, plant, equipments, machinery, manufacturing processes or the materials or substances, and they can give order of such directions to such authorities or officers or persons. So as it may consider necessary to take the steps for what? For prevention, control, abatement of the environmental pollution in our country. So role of central government is very crucial here. Again, they establish and recognize the environmental laboratories or other institutes to carry out functions entrusted to such environmental laboratories and institutes under this act. Again, they collect and disseminate the information in respect of matters related with environmental pollution. So it is their duty as part of this act. So again, preparation of manuals, codes, guidelines relating to prevention, control and abatement of the environmental pollution. So under chapter 2, the central government, so if consider necessary or expedient so to do for the purpose of this act, so by order so published in official gazette, constitute an authority or authorities. So by such name or names may be specified in order for the purpose of exercising and performing such powers and functions of the central government under this act. So it gives assurance about institutions, authorities to monitor, to control, to prevent, to abate, appointment of officers and their powers and functions. The central government may appoint officers with such designations as it thinks fit for the purpose of this act, and may entrust to them such powers and functions, this is delegation of the powers, under this act as it may deem fit. So central government has power to give directions, so may in the exercise of its powers and performance of its functions under this act, central government may issue the directions in writing to any person or officer or any authority, and such person, officer or authority shall be bound to comply with such directions. Again, the closure, prohibition, regulation of any industry or operation or process. Again, stoppage or regulation of the supply of electricity or water or any other service. So this is a big power, control, which is associated with central government or its authorities. Rules to regulate environmental pollution as part of this act. The central government may make rules in respect of what? I will tell you here. The standards of quality of air, water or soil for various areas and purposes. The maximum allowable limits of concentration of various environmental pollutants, including noise for different areas. Again, the procedures and safeguards for the handling of hazardous substances. The prohibition and restrictions on the handling of hazardous substances in different areas. Again, central government can carry out prohibition and restrictions on the location of industries and carrying on the processes and operations in different areas. Again, they can develop the procedures and safeguards for the prevention of accidents. We want this. This is the purpose of this act. So which may cause environmental pollution, and for providing for remedial measures for such accidents. You will find number of rules are created under this act by now, and this is called as Umbrella Act, overall protecting environment of our country, control, abatement. Now as part of chapter 3, it is related with prevention, control and abatement of environmental pollution. So how important, what provisions are there? Let us see. No person carrying on industry, operation or process shall discharge or emit or permit to be discharged or emitted any environmental pollutant in excess of such standards which are prescribed by Government of India or its agencies or Central Pollution Control Board. So no person shall handle or cause to be handle any hazardous substance except in accordance with such a protocol, standard practices, and after complying with such safeguards which are prescribed by Government of India, its agencies or concerned authorities. furnishing of information to the authorities and agencies in certain cases. The provisions are that where the discharge of any environmental pollutant is in excess than the prescribed standards, it occurs by accident, by any event, the person responsible and the persons in charge of that place shall be bound to prevent, stop it, to mitigate, control it, the environmental pollution, and they shall also intimate the fact of such occurrence or apprehension which may occur of such occurrence. So they are be bound, if called upon, again to render all assistance to such authorities or agencies which are prescribed under this act. Again, on receipt of information with respect to the fact or the apprehension of any occurrence likely to be, the authorities or agencies shall as early as cause such remedial measures to be taken as necessary to prevent or mitigate the environmental pollution. So as early as steps must be taken by the authorities when they are informed about it. The next about powers of entry and inspection. Big power, it is associated with the authorities, and only authorities appointed by the central government and its agencies. So subject to the provisions of this section, any person empowered by central government and in this behalf shall have right to enter any at all reasonable times, any time, any place, and for what? For the purpose of performing any of the functions which are entrusted by the central government to him, or for the purpose of determining whether and if so in what manner any such functions are to be performed as per provisions of this act, or rules which are made thereunder this act. Any notice, order, direction or authorization served, made, given or granted under this act is being or has been complied with. Again, why officer may enter? For the purpose of examining and testing any equipment, industrial plant, record, register, documents or any other material object, for conducting a search of even any building in which he has reason to believe that offense under this act or the rules made thereunder has been or is being or is about to be committed, and for seizing of any such equipment, plant, record, register, document or other material object, and suppose he has reasons to believe that it may furnish evidence of the commission of an offense punishable under this act or the other rules which are made thereunder later on. So such seizure is necessary to prevent or mitigate the environmental pollution. So if they believe, if they get proof, they can do it. Again, every person carrying on any industry, operation or process or handling any hazardous substance shall be bound to render all assistance to the person empowered by the central government, and if he fails to do so without any reasonable cause or excuse, he shall be guilty of an offense under this act. Again, any person willfully delays, obstructs any person empowered by the central government, he shall be guilty of an offense under this act. Now we'll talk about the power to take sample and procedure to be followed in connection with how to take sample, and that is a power to enter. The central government or any officer empowered by it in this behalf, so shall have power to take for the purpose of analysis samples of air, water, soil or other substances from any factory, any premise or other place in such a manner as may be prescribed. So standard procedure as per protocol, as per expectations, rules, as per rules. The person taking the sample shall, okay, serve on the occupier or his agent or person in charge of the place a notice then and there in such a form as may be prescribed, okay, standard format of his intention to have it so analyzed. So in the presence of the occupier or his agent or the person, collect a sample for the purpose of analysis. Again, cause the sample to be placed in a container or containers, number of containers, which shall be marked, sealed and shall also be signed both by the person taking the sample and the occupier or his agent or the respective person. Again, send without delay the container or containers to the laboratory which is established or recognized by the central government. Now, one of the important provision under this act is that the environmental laboratories which are set up under this act, so by notification in official gazette, central government may establish one or more environmental laboratories. So as part of Maharashtra, one laboratory is in Mumbai, another is in Chiplun, and as I know, NEERI is also checking number of things. Central government may recognize one or more laboratories or institutes as environmental laboratories to carry out the function entrusted to an environmental laboratory. So under this act, this central government may by notification again in official gazette, as usual this is the condition, constitutional way, make rules, okay, specifying the functions of the environmental laboratories, the procedure for submission to the said laboratory of the samples of air, water, soil or other substances for analysis or tests, the form of the laboratory report, and again fees payable for such a report or the tests that are carried out. Next provision is appointment of government analyst. The central government may by notification in official gazette as the condition necessary constitutional way appoint or recognize such person as it thinks fit for having prescribed certain qualification, so to be government analyst for the purpose of analysis of samples of air, water, soil or other substances sent for analysis to any environmental laboratory. So rules created under this act in the same year, they have details about government analysts. Again, next provision, report of the government analysts. Any document purporting to be as a report signed by government analyst may be used as a evidence of the facts stated therein in any proceedings under this act. It has legal importance, legal value, the report which is submitted by government analyst. Again, penalty for contravention of the important part of it, provisions of the act and rules, the orders and directions. Whoever fails to comply with or contravenes any provisions of the act or rules or orders or directions issued thereunder shall in respect of such a failure or contravention be punishable with imprisonment for a term which may extend to 5 years or with fine which may extend to 1 lakh rupees or with both. and in case of failure or contravention continues with additional fine which may extend to 5,000 rupees for every day during which such a failure or contravention continues. Now, another condition related with it, punishment. If the failure or contravention continues beyond a period of 1 year, if the failure or contravention continues beyond a period of 1 year after the date of conviction, the offender shall be punishable with imprisonment for a term which may extend to 7 years. Again, offences by companies. So, who is responsible? It is explained here. Where any offence under this act has been committed by a company, every person who at the time of offence was committed or was directly in charge of and was responsible to the company for the conduct of that business, as well as the company, whole company, shall be deemed to be guilty of the offence and liable to be proceeded against and punished accordingly. So, where an offence under this act has been committed by a company and is proved that offence has been committed with the consent or is attributable to any purposeful neglect on the part of or any director, manager, secretary or other appointed officers of the company. So such director, manager, secretary or other officer shall also be deemed to be guilty of that offence and shall be liable to proceed against and punished accordingly. So if something is purposeful and it is proven, then they who is responsible, they are also guilty. Again, offences by government departments. So where an offence under this act has been committed by a department of the government, the head of the department shall be deemed to be guilty because head is responsible to manage, monitor, to give guidelines, to check out everything, day-to-day activities, and liable to be proceeded against and punished accordingly. So provided that yes, nothing contained in this section shall render such a head of the department, so if he or she proves that the offence was committed without his knowledge, and all standard practices, due diligence to prevent the commission of such offence is carried out. Offence under this act has been committed by the department of government and it is proved that offence has been committed with the consent or conveyance of is attributable to any neglect on the part of any officer other than head of the department. So such officer shall also be deemed to be guilty and punished accordingly. So chapter 6 is the last chapter as part of this act. It is a miscellaneous chapter, and as usual in other laws also you will find a provision, protection of action taken in good faith. So no suit, prosecution or other legal proceedings shall lie against the government or any officer or other employee of the government or any authority constituted under this act, or any member, officer or other employee of such authority in respect of anything which is done or intended to be done in good faith. So anything for protection of environment, so nothing is applicable, no suit, no legal proceeding against government officers, authorities. Again, cognizance of offence. No court shall take cognizance of any offence under this act except, however, there is condition, on a complaint made by. So central government or any authority or officer authorized in this behalf by that government, or any person who has given notice of not less than 60 days of the alleged offence and of his intention to make a complaint to the central government or authority or officer. Again, as part of this act, the information, reports and returns. The central government may, in relation to its functions under this act, to perform, to implement the provisions, monitor, to check, time to time require any person, officer, state government or other authority to furnish, and any prescribed authority or officer any reports, returns, statistics, accounts and other information as such person, officer and state government or other authority shall be bound to do so. It is the duty they have to provide it if it is asked from them. Again, all the members of the authority constituted and all officers and employees of such a authority, so when acting or purporting to act in pursuance of any provisions of this act or the rules or order, directions issued thereunder, shall be deemed to be public servant. This is expected. So, bar of jurisdiction. So, what is the condition mentioned here? No civil court shall have jurisdiction to entertain any suit or proceeding in respect of anything done, action taken, or order or direction issued by the central government. There are a number of issues and drawbacks also. Next provision is power to delegate. Central government may, by notification in the official gazette, delegate such of its powers and functions to any officer, state government or other authority. Yes, they have this power. Then effect of other laws. So, one provision I will tell you here, where any act or omission constitutes an offence punishable under this act and also under other act, then the offender found guilty of such offence shall be liable to be punished under other act and not under this act. Again, central government has power to make rules as part of this act and to make rules by notification in official gazette. For what? To carry out the purposes of this act. Again, the standards for environmental pollutants, the procedure in accordance with and safeguards in compliance with hazardous substances, the manner in which samples of air, water, soil or other substances for the purpose of analysis and how that sample should be taken. So, central government has power to make rules related with these I'm talking. Again, the form in which the notice of intention to have a sample analyzed, the functions of environmental laboratories, the procedure for submission to such laboratories of the samples of air, water, soil or other substances for analysis of tastes, the form of laboratory report, the fees payable to such report, like this. Again they can make rules regarding the qualifications of the government analyst the authority or officer to whom any reports or returns, statistics, accounts, okay, the other information that shall be furnished, and another, they can make rules about all other matters, related matters which are required to perform the functions as per the provisions of this act. Again, next part is related with rules made under this act to be laid down before the Parliament. So Parliament accept the amendments, or even accept or reject. Parliament has right. So every rule made under this act shall be laid as soon as, maybe after it is made, and before each house of the Parliament. So that's the end. Thank you very much for being here. Bye bye.